Okay, bon, let's go. So hello everybody. My name is Benjamin Henryon. I've started the hackerspace back in 2009 together with Peter Eeremans. Now I'm less active. I have kids and less time to do stuff. But so on professionally, I do communities consulting. And on the side, I'm still a president of the Foundation for Free Information Infrastructure, which was set up in 1999 to oppose the first attempt to legalize software patents in Europe. So my predecessor and the founders of FFI managed. So in 1998, there was a plan so there is a convention, the Munich Convention, which regulates the behavior of the European Patent Office. So if you want to have a patent in Europe, you go to the European Patent Office and you select the countries. So it's called the European Patent. You select the countries in which you want to have your patent in. And you pay renewal fees every year, and you pay also, depending on the countries, you pay a translation fee so that your patent is translated into the official language of the country. And so in this convention, in this Munich Convention, there is a list of exceptions of things that are not patentable, and in there you find mathematical algorithms, rules for playing games, and computer programs. And the plan in 1998 was to have a diplomatic conference so that this convention would be changed and the exception for computer program would be removed. Because the European Patent Office, so the law says that the computer programs can be patented. That's Article 52.2, and Article 52.3. It says that those exceptions has to be interpreted as such. And so the European Patent Office back in 1986, so they have what is called an appeal board. So if there is let's say you file for a patent and your competitor doesn't thinks it's not valid, or it was invented before, or it's trivial, they can file an opposition at some administrative tribunal inside the European Patent Office. And so those administrative tribunals, they have one instance and a second instance, and so basically you have administrative, some kind of pseudo administrative courts that says that take decisions. And in 1986 they said, if so in the VCOM decision, they said if you run a computer program in a computer, then it's not a computer program anymore, it's a computer implemented invention. So they use this as such by saying the exclusion is only the computer program that you print on a piece of paper, but once you execute it, the exclusion is not there anymore, which is borderline, because the whole spirit about the list of exclusions is that they share the fact that they are abstract. So a mathematical formula or a rule for a playing game or a computer program, they are all in abstract things. But there is, depending where you look, there is a big industry in the software area, and so it's like a big opportunity for them to make money, because the patent office, the European Patent Office, is self-financed. So they finance themselves in function of number of patents they deliver. So they have a tendency to widen the scope of patents. So this is like 1998, 99. My predecessors managed to convince multiple countries like France to oppose this, and since you need unanimity to change the treaty was not changed in 2000. with the revision of the EPC 2000, so the European Patent Convention 2000. Then basically the large patent applicants in software, multinationals, they asked, since it failed, they asked the European Commission to prepare a directive. So they made a public consultation and a directive in 2002. The Commission proposed directive to harmonize this field and to do the same as the removal of the exception, which is to allow software patents, even depending on how you read the text. But the intention was clear that it was to widen the scope to software. So they used this term computer implemented invention, and they said computer implemented inventions are like washing machines, advanced braking systems, basically inventions that are controlled by a computer, like a brake that is controlled by a computer. But if you read the text, it could be extended to any kind of software, and not only what we called later on computer-aided inventions, not computer-implemented inventions, because implemented would mean that it would just be an invention without any physical improvement. So there was a lot of pressure at the time from the open source community, because I managed to, at some point, make a blackout page, and just before the European Parliament had to vote on this, we managed to move 3,000 websites, including Linux.org, Apache.org, GIMP.org, and a very big open source project that would be down, and calling for the European Parliament to put a strict limit on what could be and what could not be patented. So the European Parliament adopted very good amendments, in the sense that they would draw a line. Mostly it's all about, it's a gray zone, and then what you try to do is to put some rules so that the gray zone doesn't expand to everything. So there is, in what was adopted in 2003, there was the German Constitutional Court back in the 70s used the criteria of controllable force of nature. So if you have an improvement in the physical field, then it's basically patentable. But if it's just a normal computer program that transfer data to another computer, then it's not. So that was 2003. Then once the European Parliament voted to have a directive, the Council of Ministers needed to agree. And the problem was with the Council was that the ministers who decide are usually Minister of Economy, for example, and the national patent offices are usually under the control of the Ministry of Economy. So the national patent offices, who are also interested to get money from there and extend the field, the patentable field, as much as possible, they were the ones lobbying against it. And so in the Council we saw this conflict of interest, because like the national patent offices were the ones pushing behind the scenes. This is not new. In the discussions on the community patent, which I will explain later, they are also interested, because half of the money, so when you pay yearly your renewal fee for a patent, they kind of receive half of it. So they are not neutral in terms of decision-making process. So what happened after is that the Council, with the Irish presidency, managed to have a majority to re-establish software patents in the text. And then it went to European Parliament, where we put so much pressure on the Member of Parliament that the big corporations that wanted to have software patents in Europe decided to call for dropping the directive. That's what the Parliament did, and push instead for the creation of a centralized court system in Europe. So that was 7th of July 2005, and 6 months later the Commission proposed a new consultation on how to get forward with creating a patent for Europe and a patent court that goes with it. So they proposed 3 options, and one of the options was to sign the European Patent Litigation Agreement. So it's like an international, it was an international treaty with all of the members, all countries member of the EU, plus the countries that are part of the European Patent Office, I mean signatory of the European Patent Convention. So like Switzerland, Iceland, Turkey, Monaco, and some others. And they wanted to, create a court system for those countries. But then people ask, how does that work with the court system of the EU? Because in the EU you have the European Court of Justice, you have the national courts that are responsible for litigating the patents, and you also have bits of laws like the civil sanctions directive, the Brussels I regulation, that is union law that is covering patents. So once you have, the European Union has some competence, you cannot say we're going to do that because they already have competence. So you cannot do it. And so there's also, once the EU has competence, there's also a case law of the European Court of Justice called AETR, which is like a decision from the 70s about a treaty about transport in Europe, which says basically that once you have the EU as competence, you cannot sign, the EU has competence to sign a deal with the non-EU countries. And so basically what we pushed for was, we pushed the European Parliament to ask its legal service if it's really legal to do this kind of construction. And the legal service of the European Parliament came out with this jurisprudence saying you cannot do this. So after that, once this was dead, they pushed for another design, which was a similar design, but also with external countries, but where the court would be competent for the community patent, so the patents were for the whole Europe, and for the current European patent where you pick your countries. And so they drafted the text, they sent it to the European Court of Justice for opinion, which is Article 218, which is, by the way, which has been used for several international treaties like CETA. So when when Wallonia was discussing CETA, the one thing that was not clear is whether CETA could be signed at all, because the EU had some competence, and also the court, the investment courts were seen as not compatible with the EU system. So 218, and then in 2010, Spain said they wanted to have Spanish as a language. So the one thing that has been blocking the patent for Europe has been the language regime. So right now you have, when you file a patent, you have to pay for translations. There is another agreement where they try to reduce the number of languages, called the London Agreement. So depending on the countries, they relax the rules for translating patents. So for example, if you want a patent in Belgium, you can file it in German, and you don't need to translate it in French or Dutch. And so that's a bit special. So in other countries, most of the time they require you to pay for a legally binding translation. And what they did, so Spain was the official languages of the European Patent Office are French, German, English. Most of the patents are filed in English. And then what they did here with the deal that Spain wanted is that Spanish would be the fourth language, and they kept on blocking the whole project because unanimity was needed. And so what the countries find out is that they could use enhanced cooperation, which is like a subset of countries could go ahead without all the countries and just move forward like this. So they did that in 2011, which is to give a mandate to go with a small subset of countries. And in the meantime, the European Court of Justice gave its opinion back, saying basically what they have, the design of what they have done is not compatible with the EU because they do it with non-EU states, but also they deprive the national courts. So the goal was to create this international court and remove national courts. But you cannot do this because national courts are responsible for EU law, and so you cannot take EU law and transfer it to an international court. So after that opinion 109, the countries said, okay, but we look at the situation, and in Europe there is one court which is called the Common Court, which is the Court of Justice of Benelux, which is used for trademarks. So when you want a trademark in Benelux, you apply for a trademark, and the trademark covers the 3 countries. And if you want to litigate it against a competitor that have a stupid trademark or whatever, then you can go to either the National Court of Belgium, Luxembourg, or Netherlands. And the fact that the law is harmonized between the 3 countries, they created what is called a common court. I think it sits. I don't know if it's in Brussels or somewhere else, but if the national court during the dispute has a question about the law that is harmonized, then they can ask a prejudicial question to this central court. The central court replies back to the court, and then they can continue the dispute. Now in trademark, there is EU law as well. So at some point in 1995, in the Dior, so the perfume Dior case, the Common Court, so the Benelux Court of Justice, asked the question to the European Court of Justice, and there was the question whether this court, which is not a court of a national court, could ask the question to the European Court of Justice on EU law because they are not part of the design of the EU. And the court said, yes, this court can ask the question about EU law because the national courts are in the loop of the whole system. So that's what they called a common court. And in the process of trying to do this patent court, they reuse that example, except so they create this international court, but they remove the national court and by saying, yeah, it's a common court, but we read the decision of the European Court of Justice on trademarks in a different way, but it doesn't matter. And so the goal to install a patent court in Europe, the goal has been the same all over since for a while, is to remove the national courts because they are not specialized in patents. They are slow. They are basically the judges do any other kind of disputes, and since they wanted to have one decision for the whole Europe on one patent, they wanted to avoid this what is called cross-border litigation, which is you have the same patent which is litigated in Germany, in France, and you have different disputes. So when we look at those arguments about trying to save money on avoiding duplication, it's a nice concept, but most of the disputes happen only in one country. So when you litigate a patent against a competitor, usually you go to Germany, and once you have a decision in Germany, then you make a deal with the competitor for the other markets, or you go to a second country, and once you have two decisions, then you also make a deal. But most of the litigation only happens in one country in Europe. So this 90% of the disputes are in one country, and 10% or even less are in two or more countries. So they came with this argument that they need to solve this problem of cross-border litigation, which is only 10% of the cases, and that's why they need to do this project. And also the problem is the cost of litigation is very different depending on where you go in Europe. For example, if you want to litigate, go to court here in Belgium, it's going to cost you 165 euros of court fees, plus your lawyer's fees, which are generally the biggest chunk of your bill. Plus, if you lose, then you're gonna have to pay the fees of the other side. And so when you go to France, the court fees are 0. When you go to Netherlands, they are like 600 euros. But when you go to Germany, they are 8,000 euros. And the second most expensive country was the UK. So most of the patent litigation in Europe was happening in the UK or in Germany. So typically, Germany they have a very special system where patent trolls like to go to Germany because they can go ask one court for an injunction to stop a product, like for example an iPhone, for example, and so they have what is called a bifurcated system, where there is one circuit for validity of the patent and the second circuit for infringement. So they go for an injunction with the infringement circuit, and then, for example, Apple, once they are sued there and there is an injunction to stop the iPhone in Germany, they file for they claim for validity in the validity circuit. But the problem is this court takes a year and a half to make a decision. But in the meantime, they already stopped the product on the market. So at the end, they stopped the product on the market, but a year and a half later, the patent was found invalid. So it doesn't. So there is like this German system is been very, very popular. I mean, the capital for this kind of stuff is in Düsseldorf, and I work in Düsseldorf for a year, where all the companies that have patents, they go to Düsseldorf and they ask for an injunction to stop the products of the counterfeiters, and they all go to Germany because of that. And in the UK, it's different because the validity and infringement, they are together. So on one side, the problem with the German system is, on one side the patentee says, yes, you are my patent is very broad, and your product is in the range of what is infringed. And when they go for validity, they say, no, my patent is very narrow, is very precise. So the whole discourse of the patentee in one circuit and the other is not consistent, because on one side they say it's very broad, and on the other side they say it's very narrow. So in the UK, those two procedures are together; they are in the same dispute. So it makes this double speak less efficient, and the dispute is much more yeah, balanced at some point. So the whole thing was so that's basically the system. And also during the software patent directive, one of the reasons to propose a directive was because the UK and German courts had different ways to interpret the exclusion. So that was also one of the reasons why this directive was proposed. So in this biggest reform of so it's called the Unitary Patent and the Unified Patent Court, is very much inspired from the German and the British system. Although the UK has during the withdrawal period, they sent their letter saying we leave the EU, so we don't participate in this anymore. So back to the timeline in 2012. So after the European Court of Justice said you cannot do this, they came with this common court excuse, saying, okay, we're going to make a common court and we're going to remove national courts. And since it's outside of the design of the European Court of Justice and national courts, they said we're gonna make a link to the European Court of Justice if there are questions about EU law. So EU law is only a very tiny portion of patent law. So the danger here is that they create a patent court which is outside of any court structure, like floating in the ocean, and most of the patent law is international law. It's not. It's based on the Munich Convention, but not on EU law. So at the end, this court will have the last word over the patents for for patents over computer programs. And that's problematic because, first of all, it's going to be mainly German judges, and it's not going to be the European Court of Justice. So they made a big progress because it's like 50 years they're trying to do this, but the European Court of Justice doesn't have a say. So the project from 2009 was kind of okay, because they wanted to create a court where the European Court, since the plan was that the European Union would sign the Munich Convention, then automatically the Munich Convention would be part of EU law, so the European Court of Justice could have had a say. But then what happened in 2011 is that large companies pressured the Commission to, since Spain and other countries didn't want to participate, they also pushed for the fact that the European Union itself would not sign the Munich Convention, so that they could avoid the European Court of Justice. And so that's the whole. That's been the whole game since they signed this agreement. So after that, they pushed the countries to ratify. So need to ratify this. And what happened was, so in most of the countries it went through without much debate. There has been impact assessment, national impact assessment procured in Poland and Czech Republic, and they came red. They became, I mean, the output of those impact assessments were very bad, because the cost to defend yourself in court was too high. So now they proposed 20,000 euros of court fees if you want to cancel a patent from a competitor, while, for example, in Belgium it's 165 euros. But Belgium ratified anyway because they think it's good for the economy. So they made a 40% reduction for small companies, but you have to go to the court and ask that the court verifies that you're not a fake small company. This procedure doesn't exist anywhere in Europe. So with the 40% reduction, it's like 12,000 euros still of court fees compared to the 165 euros that we have now in Belgium, or even the 0 euros in France. But still the ministers of justice or economy, they think it's a good idea. So in Czech Republic, they also had a national impact assessment where the court fees for an action in front of the Czech court is 80 euros. And so the business associations in Europe, they are split. So most of them are in favor, but the business associations from Hungary, Czech Republic, Poland, Spain, and Portugal, they are against it because at the end it's too costly. You have the court fees. You have also the problem that most of the cost is going to be is also in the lawyers' fees. And the other problem is that the UK injected a rule that they want the dispute to be finished within 1 year, which is not the rule in our countries for business predictability. But the fact that everything needs to be finished within 1 year, it means that if you have to defend yourself against a patent attack, you have 2 months to prepare to do everything. So you have to go like research if it was not invented before. You have to translate documents in foreign languages. You have to see if if your product actually infringes the patent, which is sometimes it doesn't match. So stuff like this, and all the lawyers says they will have to charge more because to do this job within 2 months, it's too short a time. And so also the problem is you cannot come later on with new arguments. So all your arguments needs to be filed before this 2 months period. So that's going to raise the cost of litigation, while the main objective of the whole reform was to diminish the cost of litigation by not having multiple litigation in different countries. So the goal at the end is not going to be reached. It's going to raise the cost of litigation. And so it means that small companies that already have problems to defend themselves and to afford a lawyer, they will have issues to defend themselves. So they will be forced to do bad deals outside of the court system, and close down or have bad deals where they will have financial troubles they will just have make bad deals for themselves. So the whole economic analysis around this new system is not in favor of small European companies. Grossly, the 2/3 of the patents in the European Patent Office are by non-EU companies, mostly American, Chinese, Japanese, Korean. So in terms of volume, even if you look at the current system, it's not in favor of the European economy. And inside the countries that have the most patents, it's the Germans who file the most patents among all the EU countries. So in terms of timeline, what happened is during the ratification in Germany, one patent attorney who is against the project filed a complaint at the German Constitutional Court in 2017. It took 3 years for the court to decide that in fact they did this at midnight without. So when you have a transfer of sovereignty from a national court to an international court, you need to pass this vote with 66% majority, which they didn't do. And so the court said you have to this vote is invalid, and so you might have to revote again. So the ministry, so the tricky stuff is that in order to have this treaty running, they put, so it's a treaty with 3 treaties inside, and they put as a requirement in 2 of them, they put the requirement that France, UK, Germany needs to sign so that it runs. And in the main one, the 3rd one, they put a requirement that they need like 13 countries plus the 3 countries with the highest number of patents in 2012. But when you look at which were the countries in 2012, it was the UK, the France, Germany. They just didn't hard-code it into the text. They just put another rule saying top 3 of the countries, the top 3 countries with the most patents in 2012. And what happened was, so Germany, the German Ministry of Justice initiated in 2020 public consultation with all the associations that were interested. We filed some comments saying by the fact that we already passed the Brexit date, this treaty cannot enter into force because the UK is already being left, and so this text cannot enter into force because the UK is already gone. And so they played with the fact that the UK, the start of there was a transition period called the withdrawal agreement period between the 31st of January and the 31st of December. And so they played with this game saying, but it's not the 31st of January, Brexit is not the 31st of January, Brexit is the 31st of December. So we still have to till the 31st of December to ratify this, and it can still enter into force because the UK ratified it. And so when we saw that, some people in the UK started to call on Boris Johnson to send their official deratification letter to the registry, which is in the Council of Ministers here, and which they did in July 2020. So at some point, I said we opened a bottle of champagne and said this treaty is dead. It cannot enter into force because the UK just sent its letter, and so if you read the text, they cannot. This will never be able to enter into force. And so the German Ministry of Justice kept on pushing. So they pushed for putting this ratification in the agenda of the Bundestag. And we asked, since FFI-EV is a German association which is active in the field for a long time, we asked for having public hearings in the Bundestag saying there are problems with this treaty, this setup. It's not good for small companies. We're going to have software patents with this central court and outside of the European Court of Justice. And it cannot enter into force because the UK is gone. And so when we asked that, we saw that they didn't want to organize a public hearing. Why? Because they already prepared all the meeting dates towards the tight schedule of the end of the year. And so we said, okay, if we cannot have a debate, then we're going to prepare a constitutional complaint because there were like problems with election of judges and so on and so forth. So they approved. What happened during the vote is that they had so the Greens were like they promised at the EU level that so at the EU level they voted against it, and they promised that they had a EU-wide position on software patents. So when the European elections were happening, we sent a letter to our supporters saying vote for the Greens because that's the only party that has a clear line on this issue, and you can trust them. You can trust them to vote against that. And so when we tried to contact the members of the Bundestag, the Greens, to find out their position, they didn't want to answer. And basically, we find out that they're going to vote for it. So we sent them the day before the vote. We sent them an open letter saying you promised to your voters that you would vote against. Basically, what you are doing here is you are breaking your promises. And beware, in 6 months' time, in September, there's going to be elections in Germany. So you should have that in mind. And so what happened is I sent this open letter and kind of created some fire inside, including the Greens in the European Parliament and the Greens in the Bundestag. And I did this because we had some rumors that the liberals were also skeptical. So the liberals are in power now in Germany. they asked some questions to the German Ministry of Justice with the good questions, like where is your economic impact? Is it good for small companies? And so on and so forth. And but at the end of the day, they got shitty answers. So they went through this. They approved, and we find out after the vote, someone called us saying you should have recommended. So what happened was all the democratic parties voted for it, except the AfD, which is the right-wing party. And so after the vote, we got a call from someone following and said, you should have recommended the AfD to vote abstention so that the possibility to vote no would be freed up for democratic parties. And in Belgium, it's called what's it called? Cordon sanitaire, which is like you vote against what the extreme right is voting. But for me, they don't vote on the topic. They vote comparing to what the extreme right is voting, which is not the way it should be, but it's like that. So this happened. So Bundestag passed this. Then it went to the Bundesrat, which is like the Länder, the second chamber in on 18th of December. 18th of December, they just passed it without any comment. 18th of December in the evening, we sent our complaint to the Constitutional Court, which was already prepared. And on the Monday, the press said there were two complaints. One from the previous guy who refiled the same stuff again, and us. So it took like 7 months for the Constitutional Court to say they discarded all the arguments that were put on the table and allowed Germany to ratify. And then, so the complaints are private, so it's not public. But when the court made a press release, we could see the arguments from his side and our side. And he raised the fact that the whole construction is still contrary to some articles of the Treaty of the European Union, because those articles, notably articles TU 19 and the articles about it's 267. So 267 is national courts can ask questions to the European Court of Justice and get an answer back, and TU 19 is basically to enforce EU law you need national courts, and that was clarified by the Court of Justice in 2011 in their opinion, saying if you read Article 19, which is now disputed which is used against Poland, because if you have EU law, you need some national courts, some strong national courts to enforce it. But if the national court is a kangaroo court, where the judges are put by corrupt politicians, then it's not anymore a reliable court. And that's what this article says. It says the European Court of Justice is on top, and member states needs to provide a court system to enforce EU law. And so the one thing we didn't see is so there is a very renowned, not renewable but knowledgeable institution in Germany called the Max Planck Institute. The Max Planck Institute, they have like top researchers in law, and one of the researchers left the Max Planck and now is at the University of Vienna. But basically he published a paper saying this construction is not legal, because when you look at what the European Court of Justice has decided for the last 10 years on international courts, and in those decisions you will find the one of the CETA, you will find the one about the attempt of the EU to join the European Convention on Human Rights in Strasbourg. You will find a bunch of decisions about international courts where they always say the same. They say you cannot take EU law and transfer it to an international court, you can do it, but it needs a link to national courts. So basically, for the UPC, they transferred EU law to an international court. They put a link to the European Court of Justice, but there's still a link missing to national courts. So if you take the Benelux Court of Justice, it's a court that has a link to the European Court of Justice and to national courts. And they can ask, they have a link to the European Court of Justice because national courts are in the loop. So this construction doesn't, I mean, this paper is just taking the case law for the last 10 years, but actually the basis is like the treaties from the 50s. It's basically what is Europe, what is the structure of the European Union. So now we didn't see this. When we try to make politicians aware that there is a problem, they basically put their sand they put their sand in the ground because they want the system to run. But even if they launch the system and there is this new court running with the new patent for the EU, the problem remains the same. Someone can complain and say, hey, look, try to escalate the problem to the European Court of Justice, and the European Court of Justice will come with the same logic as I've been applying. So there is also one in this jurisprudence, there is a very interesting case about investment courts. So investment courts are controversial. I mean, CETA is part of it because big companies that have invested in, for example, in mining, suddenly the state revokes their mining permission and they can sue the state for damages in those investment courts. And so, for example, there have been a lot of investment courts, investment treaties between Belgium and Slovakia, investment treaties between Belgium and Hungary. So there's been, in Europe, there's been like, I don't know, a lot, like probably 200 of those multilateral treaties about investment, where they have for each of those treaties, they have investment tribunals that are between the judicial system of Belgium and Slovakia. So what happened in 2018, there was a case of investment courts between Netherlands and Slovakia, where it went up to the European Court of Justice, and the European Court of Justice said, this court has to interpret EU law, and it cannot interpret EU law because it doesn't have links to the national courts. And so basically the European Court of Justice, they dissolved intra-Europe investment courts. It didn't make the litigation industry and big industry happy. And after this decision, so they kept on pushing the European Commission to come with a solution, but there's still no solution for that. And when the European Commission was asked about the compatibility of this patent court design with this kind of decision, they said, yeah, everything is fine. We put a link to the European Court of Justice. The EU law will be respected, but they didn't answer to the critical argument, which is those international courts, when they have to interpret EU law, they need to have a link with the national courts. Basically, the national courts are the guardians of EU law together with the European Court of Justice. And when you remove the guardians of EU law, you might have some troubles. But that was not visible for us. And the question now is how to escalate this problem to the European Court of Justice, let's say as soon as possible, because companies are gonna apply for the new Unitary Patent, and if you wait too long, it creates a fait accompli. So there is a big system running, and so the number of patents in running is gonna put pressure on the European Court of Justice to say, this is good enough. But they already said, they already said some legal researcher, when their opinion in 2011 was published, he already said maybe the European Court of Justice will also hit investment courts. In 2011, he was able to predict what happened in 2018 when the European Court of Justice got rid of investment courts. So there was someone who saw that it wouldn't stop there, that he could basically foresee the decision 7 years in advance. And so now countries are violating EU law, but then someone needs to go to court and put that in front of the court. The problem right now is that this treaty is not yet running, and what they did is the legal service of the council, they declared this. So you have 3 treaties. 2 treaties where the UK, France, Germany are hard-coded as a requirement, and they declared those into force because they had the requirement of 13 countries. So before, there were like rumors of organizing a signing ceremony where they would sign a declaration where they would rewrite the paragraph of entry into force, but they didn't do that. So for many legal observers, they did what is called a maladministration, because if they had to renegotiate, they would have to go again in front of national parliaments, and they wanted to avoid that at all cost. And now Germany is probably going to finally give its ratification letter in October, but still the condition is so what they did is they reinterpret the condition for entry into force by saying the third country is Italy. But no, the top 3 in 2012 was containing the UK, so UK is gone of the project. This thing cannot enter into force, but the entity responsible for for collecting the signatures of this treaty is the legal service of the Council of Ministers, and just say, fine, it's into force, but when you read the text, it's not. So it's also one uncertainty where even if they launch, someone could complain in the future saying, but this thing is not into force. And the question there, because it's a treaty outside of the EU, where do you go? You cannot go to the European Court of Justice because it's a treaty between some countries. So so you have also this problem that they broke the law to declare this treaty into force. So yeah, what we're going to try to do is in the near future. So we had to do fundraising for this action 2 years ago. What we might have to do again, fundraising to once the system is into force, to try to escalate this thing to the European Court of Justice, and probably they will nuke it down, or they will bow to the pressure of the big industry that wants this system for like 50 years now. No, there's no. I mean, what we saw as well is that in most countries you cannot take the justice system, and so in Hungary there's one country where the full project was analyzed by a constitutional court. Here in Belgium, I filed a complaint on 3 points, but we were too late to file it. But in Hungary, the minister asked the constitutional court to have a look at the whole project, and they say you cannot do this because the Hungarian constitution says justice is our stuff. It cannot be dispute between private persons, private companies cannot be outsourced to an international court. The way litigation justice is done in Europe is that national courts are responsible. Sometimes the European Court of Justice you can ask questions to the European Court of Justice and you have an answer back during a dispute, but the justice system is the responsibility of national courts.
Yes.
And I looked at other constitutions in Europe, and some of the countries have this requirement, but the politicians don't ask the constitutional court to look at it. They just ratify, and so even if the system is running, there are going to be complaints on. You could go to national constitutional court saying this system is not valid because our constitution forbids that kind of transfer. Voilà. I don't know if you have questions.
Not right away. Too much information.
Yeah, it's kind of. So I worked on other topics at the EU level. It's one of the most complex project because it's unique. It's not like yeah, you vote a law at the EU level, it's applied everywhere, blah. No, here it's like a super complex thing where.
Extremely frustrating as well because it takes so long.
So long, it's like.
Anything to move or to get any kind of results.
Yeah, so it's like 17 years now. I'm following this, and frankly, it's a marathon,
Yeah.
and it's not finished yet.
All right.
Okay, thanks.